think we can begin now. Welcome, and welcome to our participants on the web as well. Today, as I indicated yesterday, we're going to return for the first session to our first session yesterday. Given the significance of the concept of sustainability and sustainable development, we thought it made sense to frame both days with a session devoted to that. And we heard Professor Ali address this yesterday, and today we're very fortunate to have with us Professor Natasha Affolter, who will address it from a somewhat different perspective. Professor Affolter is with the Faculty of Law at the University of British Columbia, and she is also a faculty associate at the Liu Institute for Global Issues, as well as the Peter Wall Institute for Advanced Studies. So welcome, Professor Affolter.
Thanks very much, and thank you for inviting me. It's a real treat to see you here on a Saturday morning. I know how hard it is to make that choice, to actually get dressed and leave the house. And to all of you joining us through the web, you look terrific in your pajamas. Don't let that impede you from participating in our discussion. What I wanted to do today to open my remarks is to tell you about a meeting I attended before jumping on the plane yesterday. And this was a meeting at UBC, the sort of meeting that probably takes place across a number of universities. And the topic of the meeting was to talk about formulating a new school of policy, a new school that was devoted to governance. And one of the topics that came up was that it would be important to have a substantive focus, to isolate a single issue and to bring people's energy around that singular issue rather than focus on governance or policy as a whole. And one person put out the suggestion that we should have a school devoted to sustainability. As you can imagine, there was utter silence for a second, and then complete cacophony as everyone boiled over with their frustration of being inundated with sustainability everywhere they looked, their antagonism to putting this meaningless concept to name a school, their frustration that this was nothing more than token political correctness. It was just an eruption across the room. And this made me approach my remarks that I was going to give today with some trepidation. And so before jumping into a detailed look at the legal concept of sustainability, I want to address this pushback that I see happening because we are so overwhelmed by references to sustainability everywhere we look. Over breakfast this morning, I read this week's edition of The Economist. Almost every second page was either an advertisement by an international organization looking for a new director of sustainability, or a full-page ad by an oil company with a picture of a little bud and a child, framing sustainability in their concern for future generations. When I came into this beautiful building and quickly looked out for where the women's washroom was, I washed my hands looking at the poster that said, "Remember sustainability," that you'll see in the ladies' washroom. So we are inundated by references to sustainability. And I think this poses particular challenges for us in wanting to engage with sustainability as a legal concept, and two, being able to suggest that this has the rigor and meaning that it can actually make change in our courtrooms. And so what I want to do in today's comments really is to open up our day by a renewed focus on an assertion that there is meaning to sustainability, despite the overuse and multiple uses of the term, and to talking a little bit about what that meaning is. In the paper that I wrote for this workshop, I got a research student to help me count statutes and cite them with references to sustainability. We now have at least 85 pieces of Canadian legislation making some legal reference to sustainability or sustainable development. But despite this fact that there has been a decisive legislative intention to reflect this concept in our law, we still have this prevalent resistance, frustration, accusation of ambiguity, suggestion that sustainability is a meaningless concept. And I think if we want to talk about operationalizing sustainability, making it real in our courtrooms and in our law, we have to engage with this problem of meaning. In my remarks, I want to suggest that one of the reasons why we have problems with giving sustainability meaning is because it is a contestable concept. It doesn't have a single one-sentence, all-purpose, readily usable and adaptable meaning that we can just pick out of a tree and insert into our law. Rather, it can mean different things. And for some reason, this is become a bone of contention for sustainability, a reason for people and litigants to hate it, whereas the justice system has proved itself in multiple contexts very capable at dealing with contestable concepts. Think of justice, think of democracy, think of equality. These are all terms which are contestable and which we can still engage with through court processes. And I want to focus for a moment on the term equality, because I think this is a terrific example of a term that has, through judicial writing and scholarly engagement, taken on meaning. And these are multiple meanings. We've unraveled layers of what equality can mean and the differences between formal and substantive equality. We've enriched Canadian law through the depth of engagement with this topic. And I hope we can ultimately do something similar for sustainability. I think part of the challenge for sustainability is that it's about more than law. But we can't let general public discourses around sustainability rob us of the moment as lawyers to engage with this as a legal concept. And indeed, thinking about sustainability in law is got to be part of a bigger shift to sustainability generally. Before jumping into some talk about the concepts and meaning of sustainability, I want to make a brief diversion to talk about the term sustainable development, because sustainable development and sustainability tend to be used interchangeably, although they do have distinct meanings. I will argue that sustainability is a term that reflects a focus on ecological integrity. Sustainability, in other words, focuses on the capacity for humans to live within environmental constraints. Sustainable development has been the way that this term has been focused and most used in the 20th century. It's the way in which the concept of sustainability has been translated in Canadian statutes. And we see many, many more references to sustainable development than we do to sustainability in Canadian statutes. And so what is this distinction? Sustainable becomes a modifier of development. And I think a helpful way to think about the use of sustainable as a modifier is to think about what unsustainable development is. And we all can quite readily have pictures and images and conceptions of unsustainable development. And I think this helps us go a little ways towards giving this concept meaning. So sustainable development is economic development that is based on ecological sustainability. In other words, sustainability, and that first word sustainable, modifies the word that comes after. And we see this with other Canadian statutes as well. We have statutes that refer to regulations on fisheries, and we have statutes that talk about requirements of sustainable fisheries. And clearly these are different things. And it requires going back to that ecological core that lies at the heart of sustainability to understand what a sustainable fishery or a form of sustainable development might mean. So my starting point really is that the legal concept of sustainability begins with a recognition that we are talking about ecological sustainability. And this is much easier to remember in a number of jurisdictions that have chosen to incorporate in their law the phrase ecologically sustainable development. So in Australian statutes, when references to sustainable development are made, the language is ecologically sustainable development and the acronym ESD. And while references, when there's comparisons made between Canada and Australia, suggest that we're dealing with interchangeable ideas, I think this word at the beginning reminds us what it is about sustainability that is different than the sort of discourses that came before. And I want to spend a little bit of time talking about some legislative history that got us to this point of introducing a concept in Canadian law that has an ecological core. And this takes us to the 1997 Brundtland Commission report, Our Common Future. And I think Gro Harlem Brundtland's report has been blamed for many things. It has been misinterpreted in many ways, and it has been obscured in others. So I think it takes, even now, a look back at what that report says to sort of understand the beginning of this revolution in domestic law towards incorporating in our legislation references to sustainable development. So the 1997 Brundtland report recognizes quite clearly that human needs must be met within environmental limitations. This is a clear affirmation of ecological integrity lying at the core of sustainable development. A weak approach that has followed this report has been to suggest that this means we need to think of the environment when we make economic decisions. In other words, the environment becomes an add-on to economic decision-making. It becomes a check-the-box approach that can be satisfied through environmental impact assessment. It becomes something we add on to the way we normally do business. But I don't think that this necessarily is the message to take from this report. Rather, in focusing on the language in the report, which offers guidance in asserting that for development to be sustainable, the ability of future generations to meet their own needs cannot be compromised, we realize that a much stronger approach to sustainability actually emanates from this report. And that is an approach that looks at merging environmental and economic decision making. And this notion of integration and of merging is a very different message than adding on environmental decisions once an economic decision has been made. And I think it's around this merging that we need to pay particular attention. This is reflected later in the Rio Declaration, where Principle 4 asserts that, quote, in order to achieve sustainable development, environmental protection shall constitute an integral part of the development process and cannot be considered in isolation from it. So we're told here that we're not just modifying development and development decision-making processes. We're merging, we're integrating, we're changing the way these decisions are made. And I think that a challenge that often comes up when referring to the Brundtland Commission is the place given to development in that report. And there are frequently accusations that you can't assert an ecological primacy from the Brundtland Commission report because so much was said about development in the report. But I think here it's vital to think about the historical and international context of the report. The report was written about addressing economic development in the global south. And the references to development in that report speak very much to the fact that a focus on environmental protection cannot be at the expense of developing countries attempting to develop economically. And I think what's happened in practice is we've taken that language around economic development that was focused on the global south, and we've used it to modify or weaken the ecological premises in that report. So I think if we look back carefully at the context of the report, the ecological core is there, and the development focus was speaking to a different context, that of the global south. There's another misapprehension that comes powerfully out of the way the Brundtland Commission report has been interpreted, and that is to assert that sustainable development is about balancing. The Brundtland Commission report focused on environment and development. Since then, particularly with the Johannesburg Summit on sustainability, the social pillar has been introduced as well. And so these reports, these processes, have been asserted to represent a belief that now we need to balance all these considerations. And as anyone who is tasked with fact-finding knows, being told to balance is not the most helpful prescriptive advice. And indeed, I really feel for anyone whose task is to balance, absent no further direction. So I think, again, in paying attention to context, in realizing the ecological core, which is what sets sustainable development apart from the sort of development that preceded the concept, is a focus on carrying capacities of the planet, and that this allows us to move beyond balancing. It's not simply about putting social ideas, economic ideas, and environmental ideas in a bucket, mixing them up and seeing what comes out. It's about thinking differently about economic decision making. And I think this comes a lot from the growing knowledge that's building up, recognizing the environmental limits within which economic development takes place. And really making the concept of sustainability operable means accepting that development is sustainable if it tends to preserve the integrity and continued existence of ecological systems. It's unsustainable if it tends to do otherwise. Now, admitting that sustainability has an ecological core has both procedural and substantive implications. And a number of these implications, a number of the legal concepts that emerge from this are the topic of both yesterday's comments from other speakers and the rest of the day today. And I think it becomes impossible often to talk about sustainability absent references to certain animating principles. And these include the principle of integration, the principle of intergenerational equity, the precautionary principle, the polluter pays principle, the principle of ecological integrity, and the principle of participation. And this is by no means an exclusive list, and much ink is spilled by academics, each coming up with their own list of the principles that animate the concept of sustainability. But I want to make a couple precise points about these principles rather than go into any of them in detail, because other speakers are going to do that for you today. The point I want to make is that for lawyers, the key question often becomes the legal status of these principles in Canadian law. Many of these principles derive from international law, but the question we're concerned about is what is their legal status in Canada? And I think we often get to an unhelpful point of lumping together these principles and saying, well, what do they mean? Are they legally binding or not? Are they legally helpful or not? Are they sufficiently precise or not? And I want to suggest that it's not helpful to lump together all the animating principles behind sustainability. Each of these concepts are distinct legal concepts. The polluter pays principle might have a quite distinct legal status in Canadian law from the precautionary principle. The precautionary principle has a different status in EU law, where a lot of work on the precautionary principle has been done, than it does in Canada. In some jurisdictions, the precautionary principle is a presumption. In others, it's a principle. And so I think we tend to treat sustainability and its animating principles with a regrettable sloppiness. And part of this sloppiness goes to this tendency to group together anything that's to do with sustainability, say it's amorphous and meaningless and it's hard to pin down, without actually doing the hard work of trying to pin these concepts down and setting out not only their meaning, but their legal status in Canada. I also want to make the point that these principles that I've mentioned do not exist in isolation from each other. So sustainability offers a way to observe and to enrich the integration of these individual concepts. And I'll give you a decision from an Australian Land and Environmental Court judge where I think the judge does an admirable job of addressing this integration. The decision is Gray and the Minister of Planning from the New South Wales Land and Environment Court. In this decision, Justice Payne is tasked with understanding the significance under Australian legislation of the requirement to provide certain types of information in the environmental impact assessment process for a coal mine. And she looks at Australia's legislation and the requirements of ecologically sustainable development, and she focuses on the fact that part of ecologically sustainable development means a consideration of intergenerational equity. And because intergenerational equity informs an analysis of ecologically sustainable development, she says we have to look at environmental assessment in a far more long-term way. Here we're dealing with a mine that's going to produce coal. And the argument before her is that the environmental assessment process should be limited to understanding the footprint and impacts of the mine itself. But she holds that the requirement of ecologically sustainable development, and particularly this consideration of intergenerational equity, means that the analysis can't stop there. When we are engaged with an environmental assessment approval process for a coal mine, we can't just think about what's the footprint of the mine. We have to think about the long-term consequences of giving the green light to a development project that's going to produce coal and the greenhouse gases that are ultimately going to be emitted from the burning of that coal. And that is the sort of long-term thinking that a sustainability approach that takes seriously intergenerational equity looks like. And so her finding is that we have to, as the statute here requires, include an assessment of cumulative impacts of proposed activities on the environment. And I think one of your other presentations is going to look at cumulative impacts in more detail. And so I wanted to highlight that as a concrete example of the difference of that thinking about sustainability in quite a robust way involves. And we've had from our own Commissioner on the Environment and Sustainable Development, Scott Vaughan, a call for the federal government's draft Federal Sustainable Development Strategy to take many more steps in that direction. In other words, to engage and to refer to the principles which guide and animate sustainability, as well as to use the language of sustainability. And I think this often becomes one of the challenges. How do we move beyond the words and actually make meaning of sustainability? And part is certainly by integrating a consideration of its animating principles. To turn briefly to where we are with Canadian statutes. We have a lot of statutes that now refer to sustainable development. There certainly is an unevenness in these statutes. We have far more references in statutes in Manitoba and Quebec than in the rest of the country. We have, quite noticeably, quite a dearth of judicial comment on these statutes and their meaning. But I think that workshops such as this and attempts to robustly define and engage with the animating concepts can help. They make sustainability less intimidating, less a sort of gray area that you want to avoid at all costs, much like international law, and they become a much more tempting source of inspiration for judicial writing. And it's not that the precedents aren't there. If we look at the decision of Mr. Justice Binney in British Columbia and Canadian Forest Products, we see him go through a long line of Canadian judgments in which the ecological core of sustainability has been repeatedly affirmed by the Supreme Court of Canada. Cases including R and Hydro-Quebec, the Oldman River Dam case, Ontario and Canadian Pacific Limited, and Spraytech. And in each of these cases, we see a reference to the fact that environmental protection has emerged as a fundamental value in Canadian society and a value that's become translated into Canadian law. But we don't need to restrict ourselves to Supreme Court judgments for this. I think some of the most interesting engagement that's happening right now with sustainability and its animating concepts is happening at the administrative level with environmental appeal boards and their eagerness to translate thinking about sustainability at the ground level. Now, before I wrap up, I want to make a couple of comments about the international relevance and the international work going on around sustainability. And you have a focus session today that's going to look at the relevance of international law for sustainability discussions. So that's not what I want to touch upon. Rather, I want to touch upon the fact that its litigants, its counsel, its judges across the world who are engaging right now with the challenge of making sustainability operational. And so there's a number of places we can look for inspiration of how others are handling it. This is not to advocate that foreign law be transplanted into Canada or that we, open our arms unquestioningly to what's happening elsewhere. Rather, it's to suggest that there's real inspiration in the approaches taken in other jurisdictions and at the international level. And the first example I wanted to give was the Gabi Sikofo-Nagimoris decision of the International Court of Justice. And in that case, Judge Weeramontre's well-known separate opinion, I think gives us that sort of moment to stop and say, actually things look different if we put our thinking through a sustainable development lens. He stops and says, the world has changed. This is not business as usual. In his words, for the purposes of the present case, the parties should look afresh at the effects on the environment of the operation of this power plant. And I think it is that looking afresh that we're ultimately talking about with sustainability. The second example from the international realm is a decision of the appellate body of the World Trade Organization that was tasked in a decision where it had to interpret the meaning of GATT 1947 and its reference to exhaustible natural resources. And the appellate body said, when we look at GATT 1947 and interpret it, we have to think about the sustainability mandate that is part of the preamble to the WTO agreement. We are forced to do this because of the language of the 1995 WTO agreement. And so we, again, must cast new eyes on the language of GATT. In holding that turtles could be included with the category of exhaustible natural resources, the appellate body held that the words of the provision, quote, must be read by a treaty interpreter in light of contemporary concerns of the community of nations about the protection and conservation of the environment. As the preambular reference to sustainable development reflects the intentions of the negotiators of the WTO agreement, we believe it must add color, texture, and shading to our interpretation of the agreement. In closing, I want to suggest that the fact that Canadian legislatures have changed 85 Canadian statutes to include reference to the term sustainability is more radical than we like to suggest. Legislatures don't do this because they have nothing else to do with their time. There must be, if we're to take principles of statutory interpretation seriously, some assertion that this cannot simply be meaningless. Thanks very much.
Thank you very much, Natasha. We will, of course, take questions, and I remind people who are participating through the web that there is an email address that you can send your questions in, so we'll receive them and pass them on. I thought that was an extremely interesting discussion, especially with respect to the looseness that sometimes attaches to sustainable development. I think you should always be suspicious of a concept everyone's in favor of. And this reminds me of the early days after Brundtland, when a spokesperson for the mining industry said that they were solidly behind sustainable development, and one of the first steps they should take would be to lower the tax rate on mines so they could continue to develop, and the industry would thrive. So it definitely can be used in different ways. I wonder if I could, as I await questions, ask a preliminary question of my own. And it has to do with really something you were getting at the end, that Canadian legislatures don't just change statutes and add things in unless there's a reason. And maybe I'd like to play the devil's advocate here and suggest maybe sometimes they do if it's cover for doing bad things like gutting the Fisheries Act. So I'm not saying the federal government is going to gut the Fisheries Act, but if they did, it would be a good thing to couch it in terms of sustainable development. I'll give you just a brief example of this. You have departments of natural resources now who were the ones basically taking care of selling off timber rights and so forth, who are transforming themselves into departments of sustainable resource development. It's the same people, and they may well be doing the integration that you're talking about, but the integration is from a certain perspective. I'm not sure that the perspective has changed of those people who are doing it. For example, in the case of forestry, it's basically people who want to see forestry go ahead. So I wonder if there isn't a certain amount of formalism in paying lip service to sustainable development and giving the impression that you're doing something when it's actually an easy fix.
Terrific question, and I think there certainly is the gap between language and meaning. But I'd suggest that even getting the language in there is helpful. I'll give you the example of the old BC Environmental Assessment Act, which had a preambular reference to sustainability, which was a sufficient hook for cases like the Taku River Tlingit case to be able to proceed because of this word sustainability. So we could suggest that that was meaningless, but then why was it removed when the Environmental Assessment Act was changed? And I think that this goes more to an understanding of advocacy and business practices than perhaps law, because I think that it's very easy to use hypocrisy as a driving point for change. So I think we do see multiple references to sustainable development, the sort of eye-rolling chuckle, can you believe they've rebranded themselves as sustainable? But I think that companies and government departments do that at a risk, and that is the risk that someone will call them to account and say, okay, British Petroleum, you're holding yourself out as the world's leader in sustainable development. We're going to make you match your actions to your words. And so I think certainly the lip service thing happens, but I wouldn't suggest that it's a cost-free move, because certainly in using media, exposing hypocrites is a sort of favorite pastime of particularly effective environmental advocacy groups.
Okay, thank you. This question, I think, takes us back to yesterday's discussion. We talked about 3 pillars of sustainable development: economic, environmental, and social. And the question is, are you suggesting that the social pillar, the so-called social pillar of sustainable development, should be ignored in order to focus on ecological aspects of development?
Yeah, no, I'm not. I was restricted to a very few words in giving this presentation. And so my choice was to go back to the origins of the Brundtland Commission report and to highlight that there was a real ecological core there. The social elements have been increasingly developed since that time. And I think they are very important. And I think we see that in the way that environmental impact assessment in many contexts has come to mean social impact assessment, and that there's advocacy for greater social impact assessment. So I think a focus on the social has been a way of really enriching the concept of sustainability. And I think it's impossible to separate out humans and environment in the sort of artificial way that the pillars often suggest. So I think around issues like participation, you could suggest that participation fits within an environmental pillar, but you could equally say participation fits within a social pillar. And so I think that I'm not someone who loves the pillars approach, because I think these ideas are far more integrated and overlapping, and separating out economic, environment, and social to me seems rather artificial.
Okay. The next question refers to this need to balance again. And the question is, does existing legislation already sufficiently balance environmental protection and development? And for example, in terms of process, through things like SIA, and I presume they're the provincial equivalents, and in terms of substance, things like allowable discharge limits, standard setting, and so forth. And the question is, are these not balancing actions? What else is there to balance?
Yeah, and I'd say simple answer, no. Existing legislation isn't often particularly helpful in telling us when we need to balance, how we should balance, and what balancing looks like. And I think that there's many people in this room who engage with this legislation on a day-to-day way that would have very useful examples of how decision makers are proceeding in spite of the legislation. So I don't think we have that many examples of legislation that we can hold up and say, you know, this is terrific, let's do more of this. But I think that that's probably a topic that those who engage with legislation every day on the ground have far more to contribute than I do.
Okay. Before I get to this one, apart from the question of how you do the balancing, I guess, there's a question of where you do the balancing. And I thought it was interesting in the comment with respect to the Australian decision, which I think was a review of an EA process for a mine. And I guess, and certainly coming from British Columbia, which was sort of at the forefront of resource planning some years ago, is there a question of whether or not a court, or indeed even a project-specific EA process, is the place to do the balancing at all? That if the focus is going to be much wider, if the focus is at a minimum on an ecosystem, perhaps a watershed, say, or if it's even broader, should there be another process that does this, and that process more in the nature of a planning process rather than an approval process, or indeed a judicial process? But I'm not too sure what your thoughts are on that.
Yeah, I think that's a really useful comment, because when we look at judges and judicial review and the sort of cases, we have this incredibly narrow and focused moment to reflect on these really big decisions. I think it's one opportunity, but sustainability demands many other opportunities. I think the challenge is that in many ways, we have become a one-stop shop where environmental assessment is seen as our moment to talk about sustainability. And once that process is over, we have real challenges in Canada in terms of environmental assessment follow-up. But I think the question refers to what comes before, which is equally challenging in that if you get to a very narrowly focused question that needs to be worded a certain way for the litigation to go forward, you're not ultimately engaging with the bigger question of whether these are the choices that Canada should be making. And I think with what's happening, particularly around some pipeline projects, approval processes at the moment in Canada, you're getting that sort of widespread community and public engagement and asking, well, how do we make these really tough decisions? Who makes these tough decisions? Does this need to be part of a wider systemic discussion of do we promote Western oil? Do we need pipelines? Do we favor trade to Asia? I mean, they're very large public questions that I think often are very poorly handled by narrow processes that are not set up for really answering these questions.
Okay. Another question from the floor. You say that the legal concept of sustainable development begins with a recognition of ecological sustainability, but recent cuts and policy changes have reduced our already minimal ability to measure and understand ecological systems. So is sustainable development likely to be applied with more success in the future or less? And how does this affect law?
It's a tough question. I think it's hard for departments to do more and better work with less resources. I'm probably not the one to tell anyone that. But I think it also reminds us that developments around sustainability are happening everywhere. It's not that we have to say, well, if it can only come from Environment Canada. They're a great player in this, but there are a lot of other people, including everyone in this room, who also has a part to play. So I think that the idea that we can somehow delegate this to a few individuals who work for certain departments with certain words in their name is probably much too narrow an approach. And I think this is partly why I quoted Judge Weeramontree and the appellate body of the WTO. Particularly the appellate body of the WTO wouldn't be seen as the sort of traditional sort of actor that's going to move the sustainability agenda forward, but they did.
Okay. Perhaps we can close just talking about that, both those. Judge Weeramontree is often cited, and I remember sitting on a panel with him once, and he struck me as someone who was very close to being a deep ecologist. The interesting thing, of course, was that it was a separate opinion, and that's always the opinion that gets cited, this one separate opinion. One might say that is more reflective of an absence of support rather than a strong indication of support. With respect to trade tribunals, I guess there are a number of decisions one could cite where the environmental community was not so happy. But I wonder if the real telling point about trade tribunals is that it's trade tribunals that have the teeth. It's not environmental tribunals that have been set up internationally that really have the teeth. And this is something, of course, environmentalists have pointed out lots of times. We wish we had the teeth of the WTO. And occasionally the WTO might get it right? But basically, they're approaching things from a pro-trade perspective. That is their mandate. And so the question is, well, if the community is really so behind a sustainable development or sustainability as a concept, why isn't there an equivalent tribunal with teeth in the environmental area? And that's a question that comes up often.
Yeah, and I think it's a good question. And I think I have a more liberal view of international institutions, and that I don't think that we need to mimic, I don't think we have to sort of have a narrow look at teeth and compliance mechanisms and bindingness. I think environmental norms are much more fluid and much more powerful. And in the trade context, I think it's easy to say that we have the WTO with teeth and we have no binding court of the environment. But nevertheless, environmental norms have been potent and persuasive, and I think they've really exercised a disciplining effect on trade and investment regimes. So each time we have a case coming up, say, through NAFTA Chapter 11, that puts fear in the environmental community, that all of a sudden now countries' abilities to pass progressive environmental laws are going to be silenced because the United States is going to have to pay out, however $100 million to a Canadian company. Although the fears are there, I think environmental norms have a disciplining effect, and we haven't seen those nightmare scenario arbitral tribunal reports happen. We haven't seen the nightmare WTO decisions perhaps happen. And so I think that we might not have a binding environmental court, but we have some pretty powerful environmental norms. And I think a flexible way at looking at how environmental norms discipline or restrain economic behavior means it's not time to give up yet.
I suppose one could, just on a footnote to that, I suppose one could look at the parallel evolution of human rights law and the long period over time which we eventually came up with an International Criminal Court and other human rights tribunals. So it may be we're just a couple of decades behind, but moving in a similar direction.
Yeah, and I think that the point of this attention to the concept of sustainable development and sustainability is to simply say there's a lot of reasons why you want to roll your eyes or not attend a session on sustainability. It's not time to give up on these concepts and the hard work they have to do in the legal arena.
Okay. Thank you very much.
Thank you.
Well, Natasha has referred, of course, to the key role of ecological integrity in all this. And so what better to discuss next than the concept of ecological integrity? And we have with us to do that Professor Sean Fluker of the Faculty of Law here at the University of Calgary. Sean.
Just give me a minute here to organize my paperwork. I've committed the sin of writing notes on two different versions of the same paper, so organize my thoughts here. Well, thanks Owen, and thanks to Environment Canada for sponsoring this session. It's a pleasure to be able to present a topic and speak about a topic that I've thought about for a long time, but in the same session, or to be able to share those thoughts with the people that are here and are listening, are watching on the internet, including interested legal scholars, lawyers, members of the judiciary, other interested members of the public. It's a real privilege to get these opportunities to have these sort of conversations. The topic of my paper and my presentation, suggests an inner look at the law and the way it approaches the implementation of environmental norms. So I started looking at the implementation of the norm of ecological integrity more than 10 years ago. I had the benefit of commencing academic work at the time when ecological integrity found its way into the Federal National Parks Act, and it was a time period with with lots of debate and lots of discussion, and it really gave me a solid platform to sort of dig in and do some really heavy lifting on understanding the concept of ecological integrity. Over time, so from a very sort of non-scientific perspective, thinking that I've sort of mastered what ecological integrity might mean, I do believe it has a very specific and identifiable meaning, and as a norm, it doesn't suffer from the sort of potential shortcomings that other concepts in the environmental arena might suffer from. Over time, my thinking and my analysis has shifted more to the legal system, and that might just be a product of being someone who thinks about law all the time and teaches law. But I have come to convince myself, anyways, that the real issue when it comes to implementing environmental norms is not the norms themselves, but it's the legal system, and it's the way we approach the implementation of environmental norms within the legal system that's where we should focus our attention. I've had the benefit to have these sort of conversations with members of Parks Canada. I haven't engaged with the judiciary to any significant extent, so I'm very excited to be here this morning to start doing that. The paper that I've provided for the session is really a case study looking at how Section 8 Sub 2 of the Canada National Parks Act has been implemented by the judiciary in terms of directing Parks Canada's management decisions within the national parks. And my paper really has two observations facially to make. And the first is that this provision, despite its very clear and focused message, has done very little, if anything, to change the direction of how the parks are managed. In fact, more recent developments suggest to me that parks are actually shifting back to an earlier phase when the parks for people mentality really governed how the national parks were managed in this country. There was a time period between the 60s and the 90s where you started to see a real shift from that to sort of the preservation of nature as sort of the main purpose of the parks. And that's the mindset that the norm of ecological integrity was developed within and ultimately found its way into the legislation. So the first observation of the short paper is just to demonstrate that this law has done nothing to change that direction. And that the second purpose of the paper is to provide a critical reading of the interpretations given by the judiciary to that section. My presentation, my approach, and my paper is definitely presented from a critical perspective. Underlying my message and my thinking is that, as the crits would put it, the law in fact beats to the economic drum. But I'm not fully a crit, because, at least not for the purposes of today, because part of the message that I want to send is that there is a role for law here if we can sort of reevaluate how we think about law and how we reason through, legally reason through environmental issues. So the problem, if you like, is that the law is tinkering at the margins. Right? Notwithstanding many of these comments that have been iterated several times over the last day and a half, and that all of us are familiar with, there's really been no meaningful change on the ground, so to speak. Right? I don't know how much more clearly you could put environmental protection as an important component of our society and the legal system, given that these statements come from the Supreme Court of Canada, other than how they've been put. Right? Notwithstanding those statements, if you agree with me that the fact that we're having these sort of discussions suggests that the law really hasn't shifted significantly in the last 20 or 30 years, then you start to think about reasons for that, and the reason that I'm putting forward this morning is that it's the statutory nature of environmental law that is in fact part of the problem. And the case study that I'm putting forward is demonstrated to suggest that suggest this hypothesis, and more work needs to be done. Right? I mean, in building on this case study, I need to look at things like comparing and contrasting the development of principles within a statutory framework versus those in a common law framework. There's the elephant in the room. There's the constitutional framework that can be implemented, as Professor Glavianos was discussing yesterday afternoon. And I don't want to go there, but it is curious as to why it requires a constitutional question to get the sort of creativity in legal reasoning that I think is required to actually implement environmental norms. And Natasha, I think, was suggesting similar thoughts before me, and so I think I'm going to speak to what she had to say here, and I think our discussions will flow together well. A few words about ecological integrity. So I take the starting point of the norm of ecological integrity to come from Aldo Leopold. Aldo Leopold's land ethic, which many of you will be familiar with, coming out in 1949. Subsequent to that, the idea of biological integrity finds its way into policy, North American policy anyways, in the 60s, late 1960s and into the 1970s. There are a number of high-profile forums sponsored by the Environmental Protection Agency in the United States looking at the incorporation of integrity into environmental statutes, in particular the Clean Water Act in the United States. And out of those forums comes a very detailed and precise understanding of what exactly we mean by integrity. Certainly a debate about competing perspectives in the context of, well, is ecological integrity only present where humans are not? Is there a role for human judgment in deciding whether ecological integrity exists or does not? And so there's a solid ground upon which to develop policy and ultimately law concerning the implementation of this norm. I'm looking at the Canadian Federal National Parks. It's a good case study because it's a closed study, if you like, in the sense that I can really focus in on one particular area, one particular set of policymakers, and one particular set of laws. Ecological integrity finds its way into Parks Canada policy in the late 1970s, and due to concerted lobbying efforts by parks advocates, Parliament amends the National Parks Act in 1988 to include the preservation of ecological integrity as a legal rule in Section 5.1 of the Act, as a priority as it relates to park zoning and visitor use management. This is 1988. Some of you may be familiar with the work that was done in the 1990s. Again, the federal government commissions a number of high-profile policy forums looking at the state of the parks in Canada, again, responding to the reality or the perception that the federal parks are in peril and in significant ecological decline. One of the recommendations, so there's a panel of ecological integrity formed by the federal minister, which goes around the country, visits a large number of parks with the mandate of asking, what needs to be done to halt or reverse the ecological decline of the parks. And one of the recommendations, one of the strongest recommendations coming from that panel was that the law that was implemented in the late 1980s is not strong enough, right? It hasn't done anything to change the direction of parks. We need a stronger legal mandate. Parliament responds in 2001 with the enactment of Section 8 sub 2 of the Act. Maintenance or restoration of ecological integrity shall be the first priority of the minister considering all aspects of park management. Note there is no reference to balancing in this section, right? The first priority. There's no question when you look at the underlying policy work that preceded these amendments that the purpose of the amendment was to make the preservation of ecological integrity the overriding priority in parks management. No question on that. The panel, the work was clear that mandate was needed to give Parks Canada the legal authority to say no to human activity in the parks, right? That was the message given to the policymakers. Parliament responded by enacting this provision. I fast forwarded through my slides a little bit. In addition to implementing that rule, Parliament gave ecological integrity a legislated definition, as is set out in the screen. Again, very distinct from other norms where they elude definition, if you like. I mean, here's a case where you have a statutory meaning, very, very clear to the extent that you can come to grips with things like natural region, native species, biological communities, and the like. Science has done that. There isn't uncertainty in the science when it comes to some of these. There's a particular area of science in the U.S. Led by a fellow by the name of James Carr, who I had the pleasure of meeting a couple years ago. He has developed an index of biological integrity that can be used to measure ecological integrity. Parks Canada is considered a leader in the world when it comes to measuring for ecological integrity. Stephen Woodley, the senior ecological scientist, or perhaps a senior scientist with Parks Canada, I don't quite know his official title, is considered a leader on the concept of ecological integrity. He wrote this definition in his PhD thesis in the early 1990s. So the point of this is just to demonstrate there isn't uncertainty when it comes to understanding what ecological integrity is, what it requires. Right? The consensus in the parks is that ecological integrity is a state that is undisturbed by human activity. Whether you believe that's possible or not, from a legal perspective, is arguably irrelevant because the law has defined the concept to be as such. Right? So, the provision, Section 8 sub 2, has been interpreted or considered by the federal courts 5 times thus far, beginning shortly after its enactment in 2001 and carrying forward as you see on the screen. A couple of observations across these interpretations. First of all, every one of these cases involves a judicial review application. That's important for the purposes of what I have to say in a minute. Secondly, in every case, the court has deferred to Parks Canada's reading of what Section 8 sub 2 requires of the minister, or Parks as the minister's delegate. Okay? Deference in every case. Thirdly, and interestingly, I think, where the issue in front of Parks Canada concerns the management of people or humans or their activities, right? The federal court has sawn fit to draw into its analysis of Section 8 sub 2, Section 4 sub 1 of the Act, which some of you might be familiar with. That's the purpose provision in the Parks Act, which is the so-called dual mandate provision, the provision that states that parks are to be preserved and made use of for the benefit of, or to be made use of and preserved for the benefit of future generations. So this sort of sense of having to balance the need to preserve nature, but also for the benefit of future generations, but also make parks available for their use by current Canadians for a host of reasons. For whatever reason, the courts have, when the issue involves parks adjudicating a proposed human-based activity or some project, they read Section 4 into Section 8 sub 2. Interestingly enough, where the issue only involves the management of a non-human species, the court has no difficulty simply asserting Section 8 sub 2 alone, right? It doesn't bring 4 sub 1 in, okay? So I'm following the jurisprudence to see if this is a trend that continues, but I think for the current purposes, it's interesting to note that. Okay. The first and still leading set of decisions is the subject of my paper, and it concerns the Wood Buffalo National Park in northern Alberta and the approval by Parks Canada of construction of a winter road crossing the park from west to east or east to west, what have you. The Canadian Parks and Wilderness Society, members of whom I've spoken to in relation to other research projects, really saw this decision as the ideal set of facts to test the strength of this new provision in the Act. Here you had a case only several months after Parliament had amended the statute to add Section 8 sub 2. Here you have a case where there were noted environmental adverse impacts of the project on a relatively remote and undisturbed park. The rationale for the road was economic or commercially related. It was intended to aid in the transportation needs of the remote communities in the area surrounding the park. And the minister, despite having commissioned all of this work on ecological integrity, doesn't even mention the term in her approval. There's no record of considering ecological integrity in the decision-making process. So CPAWS goes forward on the basis that let's get a good precedent on the record here concerning what Section 8 sub 2 requires of Parks Canada. Let's implement the preservation of ecological integrity into the national parks of Canada, right? Much to their dismay, they run into a bench, and I wasn't there, but this is from interviews I've had with people who were there. They run into a bench that's really not swayed by the environmental evidence, right? A court that is more swayed by the needs of the communities in and around the park and the service and the how the road will serve those needs. And that's fair enough, but what comes out of the decision is what's been problematic going forward, and that is the court's interpretation of Section 8 sub 2. So Justice Gibson provides us with two paragraphs in the first Wood Buffalo case, which I have cited in my paper, and I've just got a number of key quotes that come out of that interpretation. So the first one's been on the screen for a few minutes. Again, first priority doesn't mean sole priority, I guess is how you read the first quote. Somewhere, out of nowhere, comes Section 4 sub 1 of the Act, and this notion of balancing. And we've talked about balancing a little bit already today, and it's come up yesterday as well. From a critical perspective, when you see reference to the word balancing in legal reasoning, you know one thing. One side of the balance is about to be marginalized, right? It's competing interests. It's impossible to balance. It's simply masking the reality that there's competing interests here and one's about to be marginalized. Which one gets marginalized here? The ecological interest. Right? The court has no difficulty saying it's unreasonable, not unreasonable, to give special consideration to the economic interests driving this road. Again, 4 sub 1 is not relevant. The Parliament did not make 4 sub 1 or make section 8 sub 2 expressly subject to 4 sub 1. It gets better. Not only is it a balancing, but it's reasonable for parks to conclude that those interests can actually override the first priority of ecological integrity. Nowhere in the statute will you see that. That's directly conflicting with the literal meaning of the provision. Right? First priority doesn't mean determinative factor. And the court has to acknowledge that the record doesn't even refer to the term. Nonetheless, as a whole, that doesn't mean that it wasn't given first priority. So, and there's just a list of... The main point is that the section's been significantly read down by the court. In this case, CPAWS appeals the decision to the Federal Court of Appeal arguably fares worse there, where Justice Evans concludes or states more directly that the court will not revisit what Parks Canada's decisions are when it comes to ecological integrity. And as well, CPAWS, you didn't provide any evidence to the court to demonstrate how this road would adversely affect ecological integrity. Well, wait a minute. The obligation's on the minister. How does the burden so easily shift to CPAWS? Right? So that's the leading case on the interpretation of this section. What does it stand for? 1, ecological integrity is simply another factor to take into account when it comes to parks decision making, notwithstanding what the section says about first priority. 2, not only is it just a factor, it can be overridden by human interests. And 3, and this doesn't really come out in the decision, but in talking to people sort of, put it to you bluntly, this decision has had a chilling effect on the ability of parks advocates to take issue with Parks Canada decisions. Frankly, it's a hurdle that many of them believe can't be overcome, right? So what has it done? It has stalemated the law, if it's not the right word, but it has caused, the law has stopped to progress because you don't have litigants who can come forward to cause its evolution. Now, I don't have a lot of time left, so I just want to make this point. The case study and the paper suggests, of course, that it doesn't have to be this way, and interestingly enough, the Mikisew Cree commenced parallel litigation at the time that CPAWS did, challenging the road under Section 35 of the Constitution. Interestingly enough, at the trial division level, Madame Justice Hanson notes the very factors that CPAWS was trying to put forward to base her decision on an infringement of Section 35, that the road approval would infringe Section 35, habitat fragmentation, adverse environmental impacts. And that notably, the Supreme Court of Canada, when it ultimately hears the case several years later, endorses this finding. The point being, the environmental impacts and the ecological integrity of the park, the whole point of the CPAWS litigation that gets lost at the federal court on that side is arguably carrying the day in the Mikisew Cree litigation, even though ecological integrity is not facially relevant in that litigation. Right? It's an interesting contrast, and for me, strip away the Section 35 for a minute, and again, I sort of started out with that earlier. It's an interesting contrast in legal reasoning. I draw a number of conclusions from this, from the work I've done in the past and in this comparison. The first is, and I'm just noting what others have demonstrated, there's a strong correlation between utilitarian ethics and thought and statutory rules. There is some evidence, I think, to suggest that statutes are incapable of implementing categorical norms. Right? So it's inevitable that they will be read down in interpretation. Reading down typically means balancing, and as I've suggested, balancing is not something that can be done, and Natasha has I think, suggested that she's sympathetic to those that have to engage in that. I think it's an impossible task. Right? I think it's an impossible task. It's really about competing interests. Right? It's really about competing interests. Balancing is what Justice Gibson does in the CPAWS litigation, and that decision demonstrates the fate of environmental norms, I think, in the majority of cases. Statutory rules breed formalism and legal reasoning. What do I mean by that? Well, judicial review, for those of you that are familiar with it, involves deference, right? This idea of adjudicating lines. The court, rather than engage in an expansive articulation of what the environmental norm, ecological integrity in this case, what that norm means, how to sort of advance it, like the law does with concepts like equality and justice and fairness. When it comes to judicial review, the courts seem overly concerned, in my view, but nonetheless very concerned with adjudicating lines between the various branches of government, the legislature, the executive, the judiciary. It drives the legal reasoning in judicial review cases, right? It's either that or it's a question of statutory interpretation, which is also a very formalistic exercise. The point is, implementing environmental norms requires the creativity that formalism strips away, right? The opportunity for that type of engagement ends up at the administrative level, and the court never seriously engages with the implementation of the environmental norm. Right? And the last point is that the very fact that environmental law is driven largely by statute reinforces the notion that environmental issues are just politics. Right? And you'll see that from time to time where the court will dismiss an application as non-justiciable because there's insufficient legal content, right, to argue the case. And the fact that environmental laws are primarily statutory just reinforces that notion. The argument being that, for the legal system to implement environmental norms, it needs to start seeing environmental issues as broader legal issues, right? Questions of law. Thank you.
Thanks very much, Sean. Okay, Okay. From the web, it would seem that you were not surprised that the radical change to Section 8 of the National Parks Act did not lead to any real on-the-ground changes in the management of our national parks. What you are saying is that references to sustainability and similar concepts in statutes and regulations influence state action in only a very marginal way. More typically, such references merely provide moral cover, social license for business as usual. It is striking how different your analysis is from your co-panelists' much more sanguine view of the radical differences, references to sustainability, etc., in the statutes. Can you comment on the differences and similarities between your approach and that of Professor Affolter?
Well, I actually didn't think that we were sending radically different messages. I think the attachment to her paper or the reference to the roughly 85 statutes that include reference to sustainability was really just adding context to her overall message that we need to look beyond that or deeper than that to really implement norms like sustainability. So I guess I didn't see our presentations as necessarily being that different.
Okay. Next question. Can you comment on the definition of ecological integrity in the Parks Act? I find it almost unintelligible. And was it reviewed in the cases that you cite?
No, it was not reviewed in the cases that the court hasn't really grappled with the definition. I'm not sure I agree that it's incomprehensible. It really speaks to the notion of sort of undisturbed nature, if you like, so-called wilderness, and it references a lot of concepts that have undergone significant scientific rigor to sort of, it's a very scientific decision, if you like.
Yeah. Have interpretations of ecological integrity engaged with the premise from First Nations customary law that the land and the people cannot be separated?
That depends on what perspective on ecological integrity you take. As I mentioned earlier, there are some perspectives on the concept that believe that it does necessarily include a human judgment and human role, and that, in other words, what ecological integrity stands for is what we believe to be a desirable relationship between our communities and the land that we sustain ourselves off of. And so that perspective, I think, would very much align closely with Aboriginal perspectives on land and land use. The perspective of ecological integrity that's written into the Act and that sort of was brought forward with the policy work underlying the amendments to the Act is very much a romantic version of ecological integrity that separates nature from people and paints ecological integrity in its paradigm state as an undisturbed and untouched portion of lands, if you like. So I think it depends on what your perspective is, and the perspective that's written into the Act it's very romantic. And I'll add, if I can, to that answer, because it allows me to bring up something that I didn't touch on earlier, and that is, in the Mikisew litigation, ironically, Parks argued at the court in the Mikisew side that Aboriginal hunting was incompatible with ecological integrity in the park, and it's hard to miss the irony there that on the other side of the litigation, Parks is arguing that the road is not. But nonetheless, I guess Parks' position in relation to the Mikisew case suggests that Parks too, at least sometimes, adopts more of a romantic view of ecological integrity.
Okay. The next question is a very perceptive one, because I was thinking of it too. So, and that is, you noted that all the cases you cited were judicial review applications. Does judicial acceptance of the significance of expertise in the administrative law standard of review analysis mean game over for ecological integrity in statutory interpretation? And I guess an extension of that might be, if these weren't judicial review cases, do you think that the courts might have been more open to actually thinking about 8.2 in their own terms?
Yes, I think that's one of the points I'm trying to make, is that if these were somehow conceptualized outside of judicial review, however that might happen, or if judicial review meant something different than what it means today, the court would have to wrestle with the issues in Section 8 sub 2. The notion of administrative expertise, to some extent lies at the core of the formalism in judicial review, right? I mean, so if you have, and it's a particular problem for environmental norms, because again, and if you adopt a more critical perspective that the state and the law beat to an economic drum, then as others have argued, it's somewhat naive to expect the state to legislate constraints on, on that welfare. And so deferring to the expertise of administrative officials very much constrains the ability of courts to effectively implement environmental norms. And in fact, it seems like it's a showstopper.
Can I just extend that question a little bit and ask you, somewhat provocatively, I guess, whether it's not also naive to think that judges left to their own would all of a sudden become deep ecologists? If you look at the chances when judges have been free of statutory formalism, if you will, and track the common law and the environment, there's certainly times when they've moved, but they've often reflected economic interest. I'm thinking of something like Rylands and Fletcher, for example, right, in tort law. Would we expect the common law to have done any better than statutes in that respect? Given that
in light of these
a common critique of the common law is that it does, in fact, also march to the beat of that drum.
Presumably, in light of these statements, which come from the Supreme Court of Canada several times, that there would have to be some grappling with, sort of linking these fundamental values of environmental protection to the sort of reasoning that would be engaged when it comes to implementing environmental norms. I would expect it to be a difficult exercise for an appellant court today to simply assert economic rationales in light of these sort of principles. But at the very least, even if I'm wrong in that regard, at the very least, you would hopefully get sort of reasoned analysis on sort of what the norm is, what it requires, and what it means for the purposes of legal obligations, either on government or other actors. As it stands now in a judicial review scenario, it's a rare case. I should say, obviously there's exceptions to everything, and I'm not aware of a good Canadian exception, but some of you will be familiar with the TVA versus Hill litigation from some 30 years ago now under the U.S. Endangered Species Act, and that's a case where the court really did look at a statutory rule and say, well, that's what it says. It says, the snail darter is to be protected, and this dam can't proceed. And there's no reference to balancing requirements in the Act. We don't have that role. Is that really? Does the court really engage in the sort of holistic or organic reasoning that I'm sort of envisioning? I'm not sure, but nonetheless, there are the odd glimmers. Yeah.
I wonder if we go back to the Wood Buffalo Road decision and your comments there about balancing. And it actually goes back to something I was talking about in terms of Professor Affolter. The idea that anytime you have balancing, there are competing interests, and one side's going to be marginalized. And in your view, I think this will, if not always, at least typically view to lead to economic interests predominating. That actually tied into some of the concerns I'd mentioned with respect to renaming departments and allowing the integration to take place, that is, the balancing to take place within a department that has traditionally, under another name, been regarded generally as promoting development interests. But I wanted to go even broader than that and suggest that if that's always the case, if that balancing is always going to be tilted towards economic interest, what does that say about sustainable development generally, and sustainable development as a concept that is supposed to be advancing environmental values? Are we being way too optimistic in that respect then?
Well, my comment on balancing is more specifically related to legal reasoning and the idea of balancing. So it's really about legal reasoning engaging in balancing, and the argument being that when a judge or a lawyer talks about a case that needs balancing, it's just code or masking the fact that that particular person is about to marginalize one of the two competing interests and use a legal doctrine to hide that, if you like. So I wouldn't suggest that outside of sort of a legal, the legal context that balancing isn't appropriate language to be using. But if your question was more implementing sustainable development as a legal principle or a legal rule, to the extent it requires balancing, then I would suggest that it's about one side or the other trumping, and again, I think the evidence, I haven't studied sustainable development to a large extent, but I think the evidence would suggest that the economic side of the equation carries the day overwhelmingly.
I was actually sort of harking back to some remarks I made at the very beginning yesterday, the old saw that went around the environmental community that for sustainable development, developers get the noun and environmentalists get the adjective, which I think is also sort of the point that was being made earlier.
Yeah. And I mean, the marginalization could go either way, but it just so happens that because the law beats to an economic drum, it always seems to side on that side. So.
Okay. There are no other questions? Okay. Thanks very much, Sean. I appreciate that. We are now going to break. And we'll return at 11:45. And then we'll be hearing from some of these terrible environmental international lawyers you've been hearing about. Thank you, Sean.